and in Brooklyn, you were quoted as saying that basically the Supreme Court should not be deciding matters of national security, and you're quoted as saying, the Supreme Court does not know diddly about the nature and extent of the threat.
Diddly. Did I say diddly?
That's what you're quoted as saying. It's truly stupid, you went on, that my court is going to be the last word on it. First of all, did you say that?
No, I think I probably did. I certainly believe it.
What did you mean? Justice Ginsburg, please.
I don't think we have a choice. You know, the court doesn't decide we're going to pick this area and straighten it out today. There are petitions for review. And if there is a law that the government says was violated and the other side says, no, the government can't do this, can't engage in that kind of surveillance. If that case comes to us, we can't run away and say, well, we don't know much about that subject, so we won't decide it.
You know what I was talking about? This related to the Fourth Amendment, not the Fifth Amendment. The Fourth Amendment, which prohibits unreasonable searches and seizures. All right? The first time my court had a case involving wiretapping, it held that the way the Fourth Amendment reads is the people shall be secure in their persons, houses, papers, and effects, possessions, against unreasonable searches and seizures. And the court said, quite properly, hey, conversations are not persons, houses, papers, and effects. Wiretapping may be a very bad thing. States had laws against it, but it does not violate the federal Constitution. All right? About 20 years later, during the Warren Court, we did a 180-degree turn. And we said there are penumbras and emanations, and conversations are covered by this vague right of privacy that's contained in the Constitution. Now, that is the living Constitution, okay, changing what the text says and what it originally meant. The consequence of that, I was pointing out in Brooklyn. I like Brooklyn. The consequence of that is that now the institution of the government that is going to decide this highly significant NSA question about, you know, who can, what information can you get by wiretapping? The institution that will decide that is, without a doubt, the institution least qualified to decide it. It will be my court. It's a question of balancing the emergency against the intrusion. When the emergency is high enough, you can have a higher intrusion. It's why we all get searched when we board an airplane. That's a terrible intrusion upon. Well, just let me finish. We know nothing about the degree of the risk. Nothing at all. The executive knows. The Congress knows. We don't know anything. And we are going to be the one to decide that question.
So what do we do when the case comes to us? Before you answer that, I would like to remind everyone that in the wiretapping case, the argument that wiretapping was not an unreasonable search or seizure, there was a very strong opinion the other way by Justice Brandeis. So, and if I were on that court, I would have voted the way he did. I'd like to know how Justice Scalia distinguishes that kind of intrusion by the government from the decision you made in the heat emissions case. Now the helicopter that was flying over Ruth to test the level of heat, because it was of a certain heat, then maybe marijuana plants were growing. That the helicopter never touched the roof, and yet you said that was a violation of the Fourth Amendment. That was an unreasonable
because the people were not being secure in their houses from unreasonable. So I mean, that's a clear example of one of the facilities that is protected by the Fourth Amendment.
So to wiretap someone in their house?
Yeah, if you have to break into their house to wiretap, yes. But if you listen into conversations, you know, when they're in the phone booth, intruding upon their generalized right of privacy.
Well, you don't have to worry about that. You don't have to worry about that anymore. There are no phone booths.
You're right about that. You're right about that.
Let me ask you this.
But anyway, we've gotten away from the Fifth Amendment, haven't we?
No, I want to
right.
stick with this.
First Amendment.
Yeah, but stick with the Fourth Amendment for just a sec. And I don't know terribly much about it, and I acknowledge that up front. But my question is, could data that is considered terribly important either by the media or by the government, stored in a computer or stored in a cloud up there somewhere, be considered effects, one of the four words you use?
That's very perceptive.
And
I've thought about that.
Thank you, sir.
I've thought about that.
Thank you. But if you thought about that, doesn't it follow that the U.S. government would not be able to justify its NSA surveillance program, and therefore conceivably could be in violation of the Constitution?
No, because it's not absolute. As Ruth said, there are very few freedoms that are absolute. I mean, your person is protected by the Fourth Amendment, but as I pointed out, when you board a plane, somebody can pass his hands all over your body. That's a terrible intrusion. But given the danger that it's guarding against, it's not an unreasonable intrusion. And it can be the same thing with acquiring this data that is regarded as effects. Depends on how. And that's why I say it's foolish to have us make the decision, because I don't know how serious the danger is in this NSA stuff.
But don't you in the Supreme Court have the ability to pick up the phone and call somebody at the White House and say, I have a question about...
Absolutely not.
Absolutely not.
You know, there is...
How about, we are at the mercy of whatever people happen to bring to us. If they don't bring it to us, we don't know it.
And we can't make a decision based on something outside the record of the case. The parties and their lawyers have to know everything, have access to everything that we will factor into our decision. I don't know how many times I would have loved to call law professor so-and-so, who is the biggest expert
Call your
in the
husband
era.
in a tax case,
Right.
for example. Marty
Right.
was one of the best tax lawyers in the country.
But we can't do that because the other side, the parties aren't there and don't have access to the same information. So we are hemmed in by the record of the case, and the court cannot resort to information that the parties do not have.
Justice Ginsburg, I want to ask you the same question I asked Justice Scalia about the data, the storage in computers, and linking that to the word effects. And if that justifiably is linked to the word effects, doesn't it follow logically that the case could be made that the government is in violation of the Constitution by this government surveillance program?
An argument can be made, certainly. But it's not an argument that either of us could answer. Well, I think Justice Scalia suggested we can't answer at all. I don't think that's all. Well, we have to answer it, we will. But we don't get questions in the form you pose them, Marvin. We get a concrete case and not an abstract question. The effects are up there. What can the government do?
Okay.
Yeah, I would answer that one, Ruth. I mean, that is persons, houses, papers, and effects. It's not conversations.
What are you
but
saying
we
there?
can't. You couldn't answer it in the abstract.
Oh, certainly not. Certainly not.
Can we expect the Supreme Court to rule on the NSA issue?
It depends. If there is a case that will begin not in the Supreme Court, but in a federal district court, and then go to a court of appeals, we do have the luxury of not having to decide things until they've been decided by other good minds, by judges in the federal trial courts and courts of appeals.
And it's not our responsibility to shape up the executive and make sure they're doing what they're supposed to, or shaping up the Congress. That's not our job. Our job is to prevent people from being harmed. If nobody's being harmed, we don't get into the matter. And even if somebody is harmed, unless he comes to us, we don't have any self-starting powers. We're at the mercy of whoever wants to bring a case, or whoever doesn't want to bring a case.